Good evening, everyone. I welcome each one of you to our Advocate on Record Aspirants Academy. This is our 26th lecture. The topic for today is what is molding of relief. But before going to the topic, it is our regular practice that we recite preamble with a sense of commitment and with a sense of sentiment, and we feel that preamble is our unity and preamble our dignity. So therefore I request each one of you to recite preamble along with me. We the people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic, and to secure to all its citizens justice, social, economic, and political, liberty of thought, expression, belief, faith, and worship, equality of status and of opportunity, and to promote among them all fraternity, assuring the dignity of the individual and the unity and integrity of the nation. In our Constituent Assembly, this 26th day of November 1949, do hereby adopt, enact, and give to ourselves this Constitution. Thank you so much, dear friends. Before moving on to the topic, I have good news to share with you all. It's a proud moment for our AOR Aspirants Academy to produce a gold medalist in the AOR examination 2024. Ms. Tanya Agarwal stood first in the AOR examination. So therefore, this is a proud moment not only for AOR Aspirants Academy, but every one of us. And it is really, we will congratulate her and we make sure that every person who secures the highest marks will be produced from our academy. So with this positive note, I would like to address the topic for today, that is, what is molding of relief? First and foremost, dear friends, I want you to travel along with me to understand what is this topic, molding of relief. So what is molding? Molding means shaping something to the desired one. So what is molding of relief? Because generally when a plaint is drafted, we seek a relief from the honorable court. But molding of relief is something is vested in the court. In the interest of justice, they will mold the relief which we are not sought for. Shaping the case to give a relief, that is what the molding of relief is. Molding of the prayer in the interest of justice. So to address this, we need to see many provisions before going to the topic. So we have understood what is molding of the relief, for which I would like to take your attention to section 151 of Civil Procedure Code. What does it say? It is the inherent power vested with the civil court, and they pass any order to meet the ends of justice. Because the draftsman who drafts the law, maybe CPC or CRPC, today is BNSS, every situation cannot be anticipated at the time of drafting. So therefore the court cannot say that I don't have any power to pass any orders. So therefore there is a residuary power, inherent power vested with the courts to prevent the abuse of the process of the court, or to secure or to meet the ends of justice, to advance substantial justice. It is always an inherent power vested with the court to do complete justice. So therefore, we will be seeing one after the another provisions where they have vested inherent powers with the courts. First and foremost is, let me draw your attention to section 151 of Civil Procedure Code. It deals with saving of inherent powers of court. Nothing in this code, see how beautifully it is said, nothing in this code shall be deemed to limit or otherwise affect the inherent power of the court to make such orders as may be necessary. First and foremost is the civil court should think that it is necessary to mold the relief. So first and foremost is it is necessary. The situation warrants. For what? For the ends of justice or to prevent abuse of the process of the court. So the key words from section 151 of CPC is, it is not restricting the powers of the court. It is an inherent power, and if it is necessary, only when it is necessary. Therefore, under exceptional circumstances, it is not a general provision. So only when it is necessary to meet the ends of justice or to prevent the abuse of process of the court, the inherent power is vested with the civil court. Now, there is one more provision in CPC, Order 7, Rule 7 of CPC. Order 7 of CPC deals with the plaint. Order 7, Rule 7 says, when a prayer is made in the plaint, it is to be specifically pleaded what is your prayer is. So the prayer must be specific in your plaint. But you cannot ask for the general prayer or general relief. The general relief can be granted by the court considering the facts and circumstances of the case as it is necessary. So therefore, in my humble submission is, whenever we draft a prayer, we always seek any relief. The final relief would be pass any other order as this honorable court deem fit and proper in the facts and circumstances of the case. So we are leaving it to the court to mold the relief. So let me read Order 7, Rule 7, dear friends. Relief to be specifically stated. Every plaint shall state specifically the relief which the plaintiff claims, either simply or in the alternative. It shall not be necessary to ask for general or other relief. So relief should be very specific. We need not ask for any general relief, which may always be given to, as the court may think just, to the same extent as if it had been asked for. But if the honorable court thinks fit that the relief has to be molded other than the relief sought, it can always mold the relief and it can grant the relief as if it had been specifically asked for. And the same rule shall apply to the written statement filed by the defendant also. So therefore, there is a fair play, fair administration of justice. When you are molding the relief which was not sought by the plaintiff, the same relief which has not sought in the written statement also, it squarely applies to the defendant. So therefore, we have seen CPC under section 151 CPC as well as Order 7, Rule 7 of CPC. Now let me take you to the CRPC, old 482 CRPC. Presently, the Bharatiya Nagarik Suraksha Sanhita, section 528, equivalent to 428 of CRPC, 482 of CRPC. What does it say? Saving of inherent powers of the High Court. This is also the inherent power of the High Court. It reads like this, dear friends. Nothing in the Sanhita shall be deemed to limit or affect the inherent powers of the High Court to make such order as it may be necessary. The key words is, the High Court must feel that it is necessary to give effect to any order under this Sanhita, or to prevent abuse of process of any court, or otherwise to secure the ends of justice. So they are giving three conditions, dear friends. One is the High Court should think that it is necessary. For what? To give effect to the any order passed under this Sanhita. So they can invoke this 528 of BNSS. Otherwise, to prevent the abuse of any process of the court, or to secure the ends of justice. So under these conditions, the inherent power can be invoked. Now moving on to the Constitution of India, Article 142. In my humble opinion, this is to do complete justice. We have seen to meet the ends of justice. To do the complete justice, it is vested with the Honorable Supreme Court under Article 142. What does it say? It is an inherent power of the Honorable Supreme Court. The Honorable Supreme Court, as it thinks fit necessary, they can invoke 142 to do complete justice, that is molding the relief. So what is the effect of that order? The effect of the order passed by the Honorable Supreme Court under 142 will be applicable within the territory of India as if it is a law enacted by the Parliament, or as if the order pronounced or promulgated by the President of India. So this is what Article 142 Clause 1 says. If we deeply read into it, the organs of the state or the organs of the government, we say it is the legislative, the executive and the judiciary. These are the basically main three organs of the state. Now by reading this Article 142, in my humble opinion, dear friends, the honorable to do the complete justice, they invoke Article 142. So judiciary has come. So what is the effect of the order passed by the Honorable Supreme Court? It is equivalent as that of the law enacted by the Parliament. So legislature has come. Who is the executive head? The President. So they are saying whether it is equivalent to the parliamentary law or the order pronounced by the President. So executive head is also there, parliamentary law is also there, judiciary is also there. So whatever the law pronounced by the Honorable Supreme Court is equivalent to the order passed by the President of India, is equivalent to the law enacted by the Parliament. So therefore, in my humble opinion, the executive, legislature and the judiciary is squarely reflecting by reading this Article 142. Now let me move on to Supreme Court Rules 2013. Where do we find the inherent powers? This is very important, dear friends. Please see Order 55 of Supreme Court Rules. Order 55 of Supreme Court Rules deals with power to dispense and inherent powers. So Order 55 Rule 6, let me read for your kind reference. Order 55 Rule 6. Nothing in these rules shall be deemed to limit or otherwise affect the inherent power of the court to make such orders as may be necessary for the ends of justice or to prevent abuse of process of the court. So one more thing, dear friends, I will read Article 142 Clause 1 also. Very important. Article 142 says enforcement of decrees and orders of Supreme Court and orders as to discovery, etc. For our purpose, we can concentrate on Clause 1. The Supreme Court, in the exercise of its jurisdiction, maybe the Honorable Supreme Court can exercise its jurisdiction, maybe appellate jurisdiction, maybe extraordinary appellate jurisdiction, or a writ jurisdiction, whatever the jurisdiction may be. The Supreme Court, in the exercise of its jurisdiction, may pass such degree or make such orders as is necessary. So very important. They should deem fit that it is necessary to invoke Article 142. For what purpose? For doing complete justice in any cause or matter pending before it, and any degree so passed or order so made shall be enforceable throughout the territory of India. So the orders passed by the Supreme Court under Article 142 is applicable and enforceable throughout the territory of India. In what manner? We have to ask ourselves this question: in what manner? In such manner as may be prescribed by or under any law made by Parliament. So, how the law is made by the Parliament, how it is effected or enforced in the similar manner, the verdict passed by the Supreme Court under 142, it is enforceable in such manner as may be prescribed by or under any law made by Parliament, and until provision in that behalf is so made in such manner as the President may by order prescribe. So therefore, dear friends, we have seen CPC, Bharatiya Nagarik Suraksha Sahita, and then Constitution of India 142 and Supreme Court rules Order 55. So in all these cases, what do we get? The message is, or what we learn from this is, the draftsman or one who is drafting at that point of time cannot anticipate all these situations in future. Therefore, the honorable court cannot say, I don't have the power, therefore I cannot grant you relief. What you have sought, it is not within my domain, therefore I cannot grant you relief. Court cannot plead that it does not have any power, because the court is meant to provide justice. So therefore, there is an inherent power, residuary power vested with the High Court, Civil Courts and the Supreme Court to do complete justice, to prevent the abuse of process of court, to secure the ends of justice. So the Honorable Supreme Court or the other High Courts or other courts have got ample power, sufficient power to provide justice. So this is what the powers that they derive from, source of power that they derive. Now, let me give you certain illustrations, dear friends. The illustration is, this is a case our office has personally dealt with. To maintain the confidentiality of the parties, I am not going to tell you who are all the parties here, but I am going to refer you as it's a matrimonial issue, therefore wife and husband. So wife has approached our office to file a transfer petition. What is the transfer petition? We are asking the wife, the client. She says that husband has filed a divorce petition before Shamli Kairana, that is state of UP. Our client wife says that she has already filed domestic violence case as well as 498 case. So 2 cases are pending before Karkarduma, Delhi. Therefore, she wanted us to file a transfer petition before the Honorable High Court under section 25 of Civil Procedure Code, seeking transfer of the divorce petition filed by the husband before Shamli Kairana, state of UP, to Karkarduma, Delhi. This is what our prayer. So we have pleaded before the Honorable Supreme Court. The prayer is seeking transfer of divorce petition filed by the husband to Karkarduma court. But subsequently, both husband and wife, husband is working in railways, wife is a school teacher, government school teacher. Both of them are working in Moradabad, state of UP. So the Honorable Court poses a very important question. Husband who has instituted a divorce case, he is not there in Shamli. And you, as a wife, seeking transfer from Shamli to Karkarduma, where you are not staying there also. But both of them are working in Moradabad, staying in Moradabad. Therefore, the Honorable Supreme Court invoked Article 142 of the Constitution of India, that is the inherent power, to mold the relief in the interest of justice. The Honorable Supreme Court had transferred the matter from Shamli Kairana to Moradabad, state of UP. So now you can ask me the question, sir, it is the client or the petitioner has sought a relief that is from Shamli to Karkaduma. But relief is molded in such a way in the interest of justice to Moradabad state of UP, which we have not claimed, but in the interest of the parties that they have transferred it to Moradabad. So this is what the molding of the relief. The prayer which we may seek, but that will not be granted, but it will be molded in such a way to do complete justice, to meet the ends of justice, and to prevent the abuse of the process of the court. I requested, my lords, the wife or our client cannot go directly to the court where in Moradabad. Therefore, she has to be accompanied by father and the brother. Now the court said, ask your father and brother to accompany you in Moradabad. And now justice at your doorsteps. Since you are staying in Moradabad, you are working in Moradabad, why do you require transfer to Karkaduma? Despite the fact 2 cases are pending. So therefore, dear friends, in my humble opinion, this is a classic case where the Honorable Supreme Court has molded the relief, which we have not sought for. Let me read that order. It appears that both the petitioner wife and the respondent husband are presently working in Moradabad, Uttar Pradesh. In fact, the lordships referring to our grounds, ground G and H of the transfer petition, the petitioner wife has urged that it would be very difficult for her while working in Moradabad to travel all alone to Shamli Kairana to attend the court hearing on daily basis. Para number 4 of this order, having regard to the facts that places of work of both the parties are the same, we consider it fit, that means it is necessary and proper to transfer in exercise of our power conferred under Article 142 of the Constitution, the matrimonial case titled so and so, transferred from the Principal Family Court Shamli Kairana to the Principal Family Court Moradabad, Uttar Pradesh. So this is the molding of relief, dear friends. I will refer you yet another case. 2014, volume 8 ACC, page number 294. I repeat, 2014, volume 8 ACC, page number 294. The name of the case is Gaiv, G-A-I-V, Gaiv Dinsha Irani, G-A-I-V, Dinsha, D-I-N-S-H-A-W, Dinsha, Irani and others versus Temtan Irani versus T-E-H-M-T-A-N, Temtan Irani and others. So 2014 8 ACC 294 by the Honorable Judges Justice Gyan Sudha Mishra and Honorable Justice P.C. Ghosh. So these are the 2 honorable judges has delivered this judgment, dear friends. So what is the principle that is evolved in this case? Dear friends, before going to this case, let me explain you the principle of molding of relief, what was discussed. The general rule is, whenever you file a suit, once you filed a suit, your rights getting crystallized. That means you cannot take a new plea. So once you have put the foundation of your case, you cannot change the foundation of your case. So your rights, your facts gets crystallized and no plea can be taken in future in any of the courts. That is the general principle. But the exceptions are subsequent facts. When it is necessary, those facts can be taken into consideration. Change in law, that also can be taken into consideration. So to mold the relief, the Honorable Supreme Court on some occasions where they have granted leave only to consider the question of law, they have very well said, we will not disturb the High Court order in the given facts and circumstances. we will not disturb the High Court order, but we will grant leave against the impugned order only with respect to the question of law. We will decide only the question of law, but we will not disturb the High Court order. This is one such situation. Yet another situation is the Honorable Supreme Court has held under section 100 of CPC, that is second appeal. So when you are filing a second appeal, the Honorable High Court is supposed to frame substantial question of law. But the Honorable Supreme Court has held, though the High Court has gone wrong by not framing the substantial question of law under section 100 of CPC, where the Honorable High Court should not have gone into the facts and the genuineness of the settlement agreement. They have gone into it. They have committed wrong. It's an erroneous order. But still, under Article 136, being a discretionary power, in these facts and circumstances of the case, we will not disturb the High Court order. See how beautifully they are molding the relief. Yet another circumstances is, we will check the correctness of the High Court order, but whatever the rights that was accrued to the litigant by virtue of the High Court order, we will not disturb that. We will not disturb the rights accrued to the petitioner or the respondent by virtue of the High Court order, but we will still see the correctness, but the rights will not be disturbed. So the molding of relief, these are all several circumstances under which the molding of relief is done by the Honorable Supreme Court, dear friends. So where do we get this molding of relief? What are the principles? The principle is discussed in this case, 2014 volume 8 ACC. So in this case, the Honorable Supreme Court has held that it originates from the Supreme Court of America. It says, the commencement of the litigation, when such events have a direct bearing on the relief claimed by a party or on the entire purpose of the suit, the courts taking note of the same should mold the relief. This rule is one of ancient vintage adopted by the Supreme Court of America. But the crux is given at para 49, in which they have said, the normal rule is that in any litigation, the rights and obligations of the parties are adjudicated upon as they obtain at the commencement of the list. But this is subject to an exception. So whatever the plea that we need to take at the very first instance. But what are the exceptions? Wherever subsequent events of fact or law which have a material bearing on the entitlement of the parties to relief or on aspects which bear on the molding of the relief occur, the court is not precluded from taking a cautious cognizance of the subsequent changes of fact and law to mold the relief. This is the principle, dear friends. Generally, whatever the plea that you need to take, you must take it at the very first instance. You cannot change the color of your case from court to court. But in exceptional situation, when there is a subsequent change either in the facts or in law, you can always bring it to the court's knowledge, because the court cannot turn to be a deaf ears or cannot turn to a blind eye to the facts and circumstances. So in such scenario, new facts can be taken into consideration, subsequent events can be taken into consideration, and they can mold the relief accordingly. For what purpose they can do all this? The reason is to do substantial justice. To do substantial justice, these procedures, these technicalities should not come on the way by rendering the substantial justice. That is the law. So procedures are only the handmaiden of the justice. Procedures is junior to the justice. So junior cannot take over the senior. So justice is always supreme. And this procedure is only the way leading to the justice. So therefore, dear friends, this is what the molding of relief is. So we have successfully discussed about section 151 of CPC, 528 of Bharatiya BNSS, then our article 142 of the Constitution of India, then Supreme Court rules order 55, rule 6 which deals with the inherent powers, and we have cited two cases, dear friends. So with this we are completing the topic for today, that is molding of the relief.